Hi there, I'm Chris Charles. I'm a real estate specialist with Provident Law. I just wanted to give you a quick update regarding short-term rentals in Arizona. But before I give you the update, let me back up and give a little bit of history of short-term rentals here in our state. Short-term rentals became real popular here in our community around the time that we had the Super Bowl 2 times ago. It was about 10 years ago. Super Bowl was coming to Arizona, Valley of the Sun, bringing a lot of tourism. And then also the thing that was happening at that time was the popularity of online sharing platforms, VRBO and Airbnb. So I think those two factors coinciding together, there really began to be a groundswell of interest and opportunity for short-term rentals here in the Valley. Around that time, our former governor Ducey and the legislature passed what's known as SB 1350, which really paved the way for the state to allow and even encourage short-term rentals here in the community. SB 1350 prohibited the state, counties, and cities from passing any legislation that would restrict short-term rentals. But that legislation acknowledged that private parties such as homeowners associations could restrict short-term rentals. So the state cannot, but CC&Rs can. So that began the journey that many associations around the state have been on for the past decade, now grappling with the question of how to responsibly regulate short-term rentals. Short-term rentals were not really a thing prior to 10 years ago. At least not in Arizona. They weren't very popular, and they weren't really on real estate lawyers' radars or developers' radars. So that's why most of the CC&Rs that we see for communities here around the state, Phoenix, Scottsdale, Sedona, we don't really see any mention of short-term rentals in the CC&Rs because it's not really something that was on people's radars back then. So they aren't restricted or regulated in any way. What we've seen happening since SB 1350 in communities that have decided that they would like to prohibit short-term rentals, we've seen the boards try to pass amendments to the CC&Rs to restrict short-term rentals. When I first started seeing this happen 8 years ago, the vast majority of the initiatives that I saw failed. So the vast majority of the time when the association took action to try to amend the CC&Rs, they were not able to secure the requisite number of votes to amend the CC&Rs to restrict short-term rentals. At a minimum, you'll have to get at least half of the registered votes required to do that. But in some cases, the CC&Rs require a supermajority, 75%, for example. I thought it'd be very, very difficult to get, majority or supermajority of Americans to agree on anything, especially something as controversial or disputed as short-term rentals. Most of the initiatives did fail. But what we've seen the last about 2 years, maybe 3 years, is now I've seen it flip the other way, where I'm seeing probably most of the time when these initiatives are held that they are getting the requisite number of votes. This now has created a dilemma for associations, for property owners, and for private property rights in our state. How and when can CC&Rs be amended to restrict property rights? When is it fair to do that? When does that pass due process requirements? I've had a number of situations where my clients exercise proper, thorough due diligence. They researched the community. They met with a lawyer, title company, realtor to determine, is this an appropriate community to run a short-term rental operations? And determined based off of the legal documents, mainly the CC&Rs, that CC&Rs were authorized use of the property. So they purchased the property, closed escrow, and then in many cases, I've seen clients invest hundreds of thousands of dollars, in one or two cases, even millions of dollars, in rehabbing the property, furnishing it, making it presentable. And many times the short-term rental investor wants the property to be the nicest property on the block. So I've had that situation happen a number of times where the clients invested all this money into the property to make it be an excellent short-term rental, only to have the community then go and pull the rug out from under them, so to speak, and amend the CC&Rs to now restrict short-term rentals. So is that fair when that set of circumstances happens, when the homeowner purchased the property in reliance on the existing CC&Rs, only then to have them amended to now restrict that property right? And so we had that question answered in the by our Supreme Court, the Arizona Supreme Court, in the Callaway decision last year. So in March of 2022, the Supreme Court addressed that question of how and when CC&Rs can be amended. And we published an article on this topic. It's on our website, providentlawyers.com. You can take a look at that. But my interpretation and summary of that Callaway decision is that CC&Rs can be amended to modify already existing restrictions in the declaration or CC&Rs, but CC&Rs cannot be amended to add entirely new restrictions that were not already contemplated in the original document. So again, there's this notion of due process or fairness. When the property owner purchased the property, was it reasonably foreseeable that the CC&Rs could be amended to impose this new restriction that's there? So Callaway gave us great guidance as investors, property owners, realtors, lawyers, on associations on how and when CC&Rs can be modified. But Callaway did not specifically deal with short-term rentals. The legal issue involved in that case had to do with the architectural committee and how and when CC&Rs could be amended to impose architectural guidelines on the property. It had nothing to do with rentals. So there's been this lingering question since Callaway of whether that holding actually extends to short-term rental amendments. Well, here's the update that I wanted to share. So we did get an answer to that question just recently. Our Arizona Court of Appeals in the Village of Oak Creek versus Bonham has now addressed that exact question. How and when can CC&Rs be amended to address short-term rentals? And so the whole, and this holding, the answer to that question has far-reaching consequences for HOAs and short-term rental operators and property managers, because if the Court of Appeals agrees with the property owner in the Village of Oak Creek case, then what that does is effectively opens the door for short-term rentals here in our state pretty generously. Because as I mentioned before, almost no CC&Rs in Arizona address that question. Almost no CC&Rs had rental restrictions or any type of guidelines on short-term rentals or even rentals. In my career, I've read, no exaggeration, probably over 1,000 CC&Rs. I can definitely count on less than one hand, or on one hand, the number of CC&Rs that actually address short-term rentals or even rentals at all. So if the Court of Appeals agreed with the property owner on that question, then that means in very, very limited circumstances can CC&Rs be amended now to restrict short-term rentals. Without further ado, I will reveal the holding of the case is that CC&Rs cannot be amended to restrict short-term rentals unless there was reasonable notice of that restriction in the original declaration. So in the Oak Creek case, the Court of Appeals did side with the property owner and ruled that the CC&R amendment restricting short-term rentals was void and unenforceable against the property owner. So that was a big, a big win for short-term rental supporters, put it that way, in our state. The other question that the Village of Oak Creek answered is whether short-term rental use qualifies or is the same as business use or commercial use. Because although most CC&Rs don't have an express restriction on short-term rentals, many of them do have a restriction on commercial use or business use. HOAs have argued that short-term rental use is prohibited under the CC&R's express prohibition against commercial use or business use. So the Village of Oak Creek case addressed that question as well and agreed with the Court of Appeals panel that had issued a case on a similar set of facts in the Horton versus Harstook case, and agreed that short-term rental use is not commercial use. It is still residential in nature, even if it's a short duration. In the Harstook case, the party was renting their property for like just weekends and those type of durations. And the Court of Appeals ruled that that is still residential use. So another win for short-term rental operators. So that's the update. Thanks for tuning in. Feel free to check back often here at Provident Law on our website or YouTube channel to get all of the latest news and update regarding legal issues that matter to you most.